There's several philosophical issues I'd like to broach today with regard to the question of the legal insanity defense. The first thing I want to say is that there's a difference, a conceptual difference between legal insanity, illness, and our ordinary language expression, crazy. Medical illness, of course, is a medical condition that has specific diagnoses and therapies, such as psychoanalysis, cognitive therapy, medicines such as Haldol, Seroquel, Librium, whereas legal insanity is a moral judgment based on whether or not, given the action and the mental state, the person is too irrational or too crazy to be held responsible. And I'm using the word crazy because it functions in our ordinary language about a person's irrationality. So the first question I want to ask is, can legal insanity as a defense be justified either by utilitarianism or retributivism? There's a popular misconception that people who aren't insane, crazy, mentally ill will pretend to be crazy so that they won't be convicted. But for example, in Michigan, it's rare for anyone to take a legal insanity plea because it's so difficult to win. Instead, we have guilty but mentally ill. And that's a case in which you serve out your sentence, for example, in a facility for the criminally insane. Let's ask first about the utilitarian's deterrence theory. Oh, and by the way, 1% of homicides are tried with the legal insanity defense, and 40% of those are successful. So it's less than 1/2% of people who commit homicide get off on a legal insanity defense. Okay, so the utilitarian theory of deterrence is questionable here in its application because if people are truly uh, not blameworthy because they have no capacity for for rational thinking, they can't be deterred. Hugo Bidau, the author of Death is Different, says that the evidence suggests some mentally ill people commit crimes in order to be executed, maybe for the publicity, fame, that kind of thing. Now, the question of rehabilitation. If there is a successful legal insanity defense, that person will be committed to a psychiatric facility where they will not be released until they have been determined to be well. Compare if we don't have a legal insanity defense, then mentally ill people will be in a prison and will not necessarily be given therapy, just drugs, and then released after serving their sentence. Another utilitarian goal, prevention, uh, whether the person is sentenced to a psychiatric facility because of a legal insanity defense or a criminal facility. Um, in both cases, while they're locked up, they will be prevented or incapacitated from taking another life or doing anybody harm. What about the goal, the utilitarian goal of communication? If there's no legal insanity defense, society will communicate their moral outrage regarding the offender's crimes and hold them morally blameworthy, even if they're too irrational to be held responsible, in which case it's unjust to treat them the same as people who do have a capacity, a fundamental capacity for rationality and autonomy. Utilitarians also have to ask about other benefits to having the defense. For example, how happy are people made if we have it? Or how happy are people made if we don't have it? This would be, I would argue, the impact on the families of a mentally ill person, the legal defenders and advocates for that person, psychologists and psychiatrists who examine and eventually diagnose and treat these mentally ill people, versus how unhappy those people are who think nobody is too crazy not to be punished. Okay, retributivists believe criminals deserve to be punished if they're morally to blame. And if so, if they're morally to blame, they should be punished because they're going to be put on the receiving end of the suffering that they caused their victim. They can understand what they did to their victim because now they're sitting in jail or prison and they're suffering. They've lost their freedom. Hegel argues that by being on the receiving end, they will pay their debt to society for their having torn the social fabric of society. And in these arguments, like Hegel's, it resembles the utilitarian argument for rehabilitation. Kant's argument, um, punishment should never be given because of social benefits like deterrence, rehabilitation, prevention, but in order to have justice done. When we get to a more thorough discussion of retributivism, I'll argue that this is circular reasoning, begging the questions. But Kant's argument as a retributivist is that these offenders have upset the moral balance in the universe by taking an undeserved benefit. So through incarceration and their loss of freedom, they pay this cost. One thing I would like to ask as a philosopher, is it an apt metaphor to describe society as in a state of equilibrium until the crime occurs? If the society is unjust and the crime is a response to a person's outrage or resentment about that injustice. Plus, a more pragmatic approach, shouldn't the criminal justice system be more concerned with protecting people's rights and not making sure bad people suffer in proportion to their evil or wrongdoing and good people don't? Okay, so then we might ask the retributivist, is it rational to defend legal punishment on the basis of doing justice, but with no other social benefits? So I want to move on to the question of the adequacy of the specific tests for legal insanity. And as I've shown in a previous class, the law approaches excusing conditions pretty much the same way Aristotle did, that an action is excusable, that the blame is mitigated if there's not voluntariness or if there's lack of knowledge. So one perspective to take on the legal insanity defense is that two of the main tests are based on these two excusing conditions. The knowledge test, also called the right-wrong test, and the irresistible impulse test, case of involuntariness. Okay, so the McNaughton test was decided in England in 1848 when McNaughton attempted to assassinate the British Prime Minister. Okay, so the issue broached in the McNaughton test, which is still used in over 30 states in the US, did the accused at the time of the action know that it was wrong? Excuse me. Know that it was wrong, and did the person know the difference between right and wrong? So one assumption of using the McNaughton test is that delusion is a hallmark of mental illness. Well, some mentally ill people know their action was wrong and knew the difference between right and wrong, but couldn't conform their conduct to that knowledge. So that's when the irresistible impulse test was added to the McNaughton test because of its approach to the lack of voluntariness. But the problem with this test, in discussing the question of was the impulse irresistible, is the problem of determining whether the the crime was irresistible or just was not resisted by the person. Okay, one interpretation is, would the person still have done the crime if a policeman were in the area? So the examples of irresistible impulse: mothers who have killed their children because God wanted them to, or mothers that have killed their children to save them from Satan. Would it be better, here's another philosophical issue, if the lack of voluntariness test be based on whether the person believed he or she had no reasonable alternatives, rather than whether the impulse was irresistible? Now, this excuse, the irresistible impulse excuse, has been incorporated into a diminished capacity excuse in jurisdictions that don't have a legal insanity defense. A third test, we've got the first one, Macnaghten, the second one, irresistible impulse. The third test, the Durham test, was used and came up in the 50s in the US, and came up with the causation test. Was the crime a result or product of mental illness? And in many of the court cases in which jurors had to decide, they were pretty much agreeing with whatever the psychiatrist or psychologist said. But as I indicated, legal insanity is not a medical condition, it's a moral judgment based on whether the person lacked the fundamental capacity for rational autonomy. But here's another criticism, and of course, this test is too broad. We want a legal insanity test that's neither too broad or too narrow. So this one is too broad because it would consider as examples of legal insanity uh, mental conditions like neuroses, depression, OCD. Anytime a crime was done as a result of those mental illnesses would qualify. In reality, jurors often ignore the instructions and the nature of the specific test, and they just use their moral intuitions to determine whether a person was too crazy to be held responsible. The last test I'm going to talk about is that provided by the ALI, American Legal Institute, Model Penal Code in 1973. A person is not responsible if at the time and as a result of mental illness or defect was unable to appreciate the criminality or the wrongfulness of the action. That's Macnaghten. And couldn't conform their conduct to the requirements of the law. That's the involuntariness test. The problem with the ALI Model Penal Code is the ambiguity of the word failed to appreciate. Does that mean a cognitive appreciation, or does it mean an emotional or moral appreciation? If it means an emotional or moral appreciation, there's a new problem, because there's a class of people who, because of their psychological makeup, the sociopath, may not be able to emotionally respond to the suffering that they've caused other people, and they don't qualify. They're excluded from the ALI Model Penal Code. But here's another philosophical issue. If sociopathy is incurable, then theoretically they will never be released because they can't be cured. So again, I want to repeat that I got the stat wrong. The legal insanity defense is chosen in only 1% of homicides and successful 1/4 of the time, not 40% of the time. So there's that issue. Is the legal insanity test too narrow? It excludes the sociopath. Too broad, in the case of the Durham case, the Durham test, where anybody whose crime was a result of their mental illness can be acquitted. I don't know how many where there. But another problem with without a legal insanity defense, the mentally ill offender will bear the stigma of being a felon or to murder and will serve his or her sentence uh, out in a prison with other offenders who can be held legally responsible. That concludes my lecture for today.